Assalamualaikum warahmatullahi ta'ala wabarakatuh and welcome to our group presentation. I'm Wardah binti Hasri and today we're going to present about Al-Hibah, which is under the gratuitous contracts in our syllabus in this subject. We start with the introduction. I think we all know when we hear Hibah, we know the meaning is a gift. But how can we apply Hibah? How the whole process and detailing about Hibah, me and my partner Amirah will explain it. First thing first, Hibah is a transfer of assets without sharing views on the part of the person who gives the present and accepting the gift on the part of the individual to whom the gift is given. A person can dispose of his property in any way he likes, provided that it does not violate legal principles and his transaction is given effect during his lifetime. Al-Hibah considered as the best alternative of asset management, which is also can be the best tool to resolve Muslim inheritance. For example, it can be solver for the distribution problem in Fara'id. We move to the definition and meaning of Al-Hibah. The term hibah is derived from the Arabic root word of habubah, which means passing or blowing. Hibah can be in the form of physical property or otherwise. Technically, al-hibah means voluntary contracts that result in uncompensated volunteer transfer between living individuals. Hibah is a transfer of legal and beneficial ownership of the asset from the donor to the beneficiary on volunteer basis. For example, without valuable consideration and compensation. Moreover, al-hibah in Islam means the act of voluntarily granting ownership of property from one person to another when the settlor or donor is still alive without asking for anything in return. Al-Hibah is one of the meritorious ways of disposal of property. Besides that, by granting Hibah, it gives us an opportunity for expecting a reward in the hereafter. Next, another meaning of Al-Hibah is a gift of love given during life. The act of hibah, whether great or small, are all praised in Islam. It shows and proves the brotherly feelings among people. In terms of law, al-hibah is a practice that is circumscribed and encouraged in Islam, especially to the immediate family. It leads to the mutual respect between the two parties. We can see the evidence from the Quran and Hadith. I provide two evidence from Quran and one from Hadith. In a nutshell, first evidence said in Surah An-Nisa verse 4, it means, but if they give up willingly to you anything of it, then take it in satisfaction and ease. While in Surah Al-Baqarah verse 177, it means, and give well in spite of love for it, to relative, opens, the needy, to traveler, to those who ask for help, and for freeing slave. Evidence from the hadith reported from Anas, meat was brought to the Messenger of Allah subhanahu wa ta'ala and it was said that it was given to Barirah as a charity. Rasulullah SAW said, for her it is a charity and for us it is a gift. Rasulullah SAW used to accept gift and exchange gift so that we may love one another. Now I'll introduce about the pillars of hibah contract. First is al-wahib, or hibah settler, which is a person who gives the hibah. A hibah settler must be an adult on sound mind, has reached full adult maturity, and is a sensible person. The settler also must be the legal owner of the property that are to be granted as hibah. He must have full authority over it. Second is al-mawhub lahu, or hibah beneficiary, which is a person who received the hibah. A hibah beneficiary can be a Muslim or non-Muslim and must have the ability to own property either as an adult mukallaf or a minor non-mukallaf. Third is al-mawhub, or asset bequeath. Al-mawhub is about the subject matter, goods or property. It must be halal and exist, and the property is not connected with inseparable property of the settler, such as trees. The ownership of the property also must be existent when transferred or handed over to the beneficiary. Last one is ijab and qabul sigoh, or offer and acceptance. Sigoh is a word or deed that carries the meaning at giving and receiving of hibah. It is subject to the following conditions. First, there is a connection between ijab and qabul. Second, not subject to certain conditions. Third, is not required with a specific time period. Next is about the condition of contract al-hibah. As we know, the subject matter must exist halal and in a good condition, owned by the party that offered the hibah, legal capacity of the parties, and must be accepted by other party. Needless to say, for a hibah to be valid, a settler at least must have a legal title to the subject matter of a gift and have a legal capacity to give away the same to the beneficiaries. First is the condition of settler. Besides be eligible to give his property, be the legal owner, mukallaf and matured, a settler also plays a condition where property ownership is only effective if he dies first. The other way around, the hibah will return to the settler. Second is the condition for the beneficiary. Temporary hibah on the condition that one of the parties is alive. Upon the demise of the settler, the property must be returned to the settler's beneficiary. Last but not least is the condition of gift. Every object which is legally tradable from Sharia perspective is considered legal to be given as a gift. The object must be exist in the time of contract, must be valuable property, and last is settler must be the owner. My final point of Al-Hibah today is flows of contract practice. From the flows given, a person who wants to make a hibah contract must be followed the requirement where the settler can meet or have a dealing with the asset management, or we call it as a trustee, to manage the asset division. Trustee is fully entrusted by settler to manage the asset. Trustee is a person who must be trustworthy and responsible for holding and managing the asset and hand it over to the beneficiaries. During the agreement, the settler shall make ijab and qabul, which is the purpose of settler wishes and intention can be expressed to a loved one. For your information, hibah trust is one of the hibah methods that is characterized by the integration of hibah and trust. The assigned property entrusted by the settler to the trustee will be handed over to the beneficiary after the demise of the settler. In addition, to preserve the rights of settler from the risk of being expelled from property by the beneficiary, a separate contract is made to enable the settler to use and manage the property until he dies. That's all from me. Thank you.
Assalamualaikum, I am Nur Amira Amanina and I will continue this presentation with the cancellation of hibah contract. Hibah can be cancelled under few circumstances, which are hibah contract that comes with a withdrawal condition. The second one is hibah asset is yet to be possessed by the donee, and the last one is hibah which is given by a father to his child. Meanwhile, after the cancellation of hibah, one of the two outcomes that will come along with the cancellation is either prior to the possession of the asset by the donee, the asset remains in the ownership of the donor, or after the possession by the donee, the asset shall be returned to the donor. However, al-hibah must not be cancelled under few conditions, which are increasing in value of the hibah asset, total loss of hibah asset, and the disposal of the hibah asset by the donee. Next, the current hibah practices in banking and finance industry in Malaysia, it is allowed in two ways, which are for the assets wealth management and for the Islamic banking products and services as a supporting financial instrument. For the second ways of hibah, it is used as an Islamic financial support for Islamic banking and takaful products and services provided by Islamic financial institutions. This type of hibah, also known as commercial hibah, due to the way it serves. Nowadays, it is very recognized that a hibah can be used in conjunction with other contracts given by bank and financial institutions. It is such as the contract of sale and purchase al-bay, lease al-hijara, kafalah al-rahnu company al-sharika, loan court, and saving al-wadiyah. Apart from that, the hibah instrument has been employed in the takaful industry either directly or conditionally. The takaful company will structure and market a takaful product to its intended beneficiaries in a direct hibah, where the takaful profits will be given to the hibah beneficiary when the takaful certificate matures. This concept of direct hibah covers the educational plan, medical plan, and other types of plan offered by the takaful company. On the other hand, The conditional hibah in takaful applies to the takaful participant's nomination of the takaful beneficiary as an executor of his estate or as the real beneficiary of the takaful benefits during his lifetime. This type of hibah is only enforceable if an event occurs such as the death of the takaful participant before the maturity of the takaful certificate. As a conclusion, Al-Hibah is also regarded as the greatest asset management option for dealing with the growing quantity of frozen assets that are unclaimed. Hibah is significant because it permits a settler or a property owner to donate a greater portion of his income to anyone, either family members or non-family members, regardless of the religion. Hibah also relies on its pillars, which are hibah settler, hibah beneficiaries, the asset bequeathed as hibah, and offer and acceptance or ijab and kabul. In hibah practice, the donor, trustee, and beneficiary must all involved in the process of implementing hibah. Meanwhile, for the cancellation of contract, few conditions must be followed to allow the contract to terminate. Lastly, we are going to discuss the past year question, which is in December 2018. Question 3C. Discuss the revocation of hibah contract based on the opinions of two mazhab. Based on the opinion of Hanafi, it permits the donor to revoke the hibah as long as no legal restriction forbidding the revocation. However, the act is considered as makruh as the donor has the right to refuse to return the hibah. Meanwhile, in the opinion of Maliki, Shafi'i, and Hanbali, it is not permissible for the donor to revoke the hibah after the qab has been made. The ownership of the gift is established by ijab and kabul and become binding through qab. However, this situation is excluding the situation where the father and mother giving gift to their son. That's all from us. Thank you for watching.